Thank you very much for joining this conference, ladies and gentlemen. La Danse des Hypocrites, a European withholding tax. We will discuss the legal and economical aspects of suffering portfolio withholding tax in the European Union, especially on dividend income, and trying to recover this, because often the foreigners who suffer this withholding tax will be, or can claim to be, discriminated against in a specific jurisdiction. I hope that we will convince you with sharing our knowledge, our insights and experiences, as Ali Kazimi just said. And maybe a little bit of a remark. We talked a lot about conflict here. I'm quite happy often that I'm working in tax law. It is the civilized form of dealing with conflict. Someone wants my money. And tax law puts this into law in general, but here especially tax law puts this into a civilized form. That's why I'm happy. Our topic, we have about 50 minutes. Let me briefly introduce the panelists, whom I would like to thank very much for joining here. We will then hear a bit of academic thoughts on the topic, and then we will discuss certain aspects of the topic between this, the panelists on the stage here. So, Ms. Rebecca Wilmot of JP Morgan, you will introduce yourself a little. Professor Alexandre Métro de la Motte from the University 12, I think is correct, in Paris. Exactly. And Jeroen van der Waal of Taxology in the Netherlands. Ms. Wilmot, would you like to start?
Yes. Hello, everyone. Rebecca Wilmot. Many of you I know or have met across the years. I sit within the tax product team at JP Morgan. So our general objective is to provide the full suite of tax services across the securities taxation arena. Personally, my specific role is responsibility for all tax matters in our EMEA region, and a global responsibility for product delivery, which includes risk matters, client matters, and ultimately service definition.
So I'm Alexandre Métro de la Motte. I'm professor in Paris. I'm professor in European and international taxation, and I'm specifically interested by the questions of direct taxation, and more specifically in European law about the question of the relationship between the fundamental freedoms and the tax sovereignty of the member states, and the question to know how it is possible to have a common market or free trade areas or relationship and law relationship between countries when you have 27, 30 tax systems working together.
Good morning, everyone. My name is Jeroen van der Waal. I'm the founder and CEO of Taxology. Taxology is a global withholding tax recovery service provider and solutions provider. And we help our clients monitor and manage their custodians' withholding tax service. And in addition to that, we help them recover withholding taxes that fall outside of their custodian's scope of services. One of those types of reclaims is ECJ reclaims. Not all custodians do that for our clients. And I've done my fair share of litigation of ECJ withholding tax reclaims, not only in the Netherlands, but also spearheading various cases across other EU member states. One example being the college pension plan case, which, if you're a little bit familiar with this topic, will probably ring a bell.
Thank you very much. My name is Stefan Gnutzmann. I'm a partner in tax law with WTS Global from Germany. The economic background, I looked up a survey that was published by Pensions Europe for the year 2020. And in this survey, pension fund vehicles, and that is a marketing term because they are not defined specifically in any rules, at least not on European level. This survey mentioned that across Europe, there are about 110 million beneficiaries of pensions, and these invest about 4 trillion euro, of course, in equity and in debt. But we see here that these are huge amounts. The percentages in equity, as we are here focusing on withholding tax on dividend income, so the percentages by country vary a bit. Of course, the amounts at stake, I heard in their estimates, 5 billion, 4 billion, 6 billion every year of withholding tax that is lost and not recovered. So the amounts here are quite significant. And just to mention a few of the entities here that we are talking about. In France, for example, there are big pension funds like Ircantec or ERAF. In the Netherlands, there are big pension institutions. In Germany, there are big industry pension funds or professional services pension funds. These, we can take this topic as far as to life insurers. In the end, the money is often has the same function. And these entities may often be able to claim that, let's say, a French pension institution is discriminated against in Germany compared to a, of course, comparable German institution. And this will be also part of our discussion. The topic is to treat equal taxpayers and tax situations equally, and unequal taxpayers and tax situations do not have the right to be treated equally. So what is equal, what is unequal in these circumstances? Monsieur Metro, would you like to give us an academic background?
I will try, thank you. We have some slides, we will comment them. So we go directly to the next slide about the question of the withholding taxes and the French and European experience. And so I will tell you how for maybe 20 years the withholding tax are working in France when there is a payment made to a vehicle, because we've got a lot of differences between those vehicles, and why we at least call that Danse des Hypocrites, because it's a topic of the panel. And so we've got there the national legal sources of France concerning the withholding taxes. Each time there is a payment which is made to a vehicle, a withholding tax has to be applied when at the beginning the payment is an international one, and it was codified under Article 119 bis of the Code Général des Impôts, and we've got a lot of withholding taxes for other situations. But to be brief and in one sentence, each time there is an international payment, there is a withholding tax. In a purely domestic situation, there is no withholding tax at the beginning. And therefore, we can see that there are two risks there: discrimination and double taxation. And therefore, how do the thing have changed, and what's that good or bad for the taxpayers? We go to the next slide, and we have to know that France is linked with a lot of states by double tax treaties. We've got more than 140 tax treaties between France and other tax jurisdictions, but with two difficulties. The first difficulty is that those tax treaties do not contain already disposals that will concern the vehicles. And therefore, those vehicles and the people after may be not protected by the tax treaties that say, for example, there is a limitation of the withholding tax or if there is a withholding tax, then there is a tax credit, for example, in order to eliminate double taxation. And therefore, those tax treaties exist, but they do not always work. And specifically, if you refer at the second point to the case law of the French Conseil d'État, which is the Supreme Court in taxation, French Conseil d'État says that the tax treaty apply to the tax residents. And the tax residents are people or companies that are liable to tax. And therefore, each time a fund is exempted by the national law of the other state, the French Conseil d'État just consider that the double tax treaty does not have to apply. And therefore, we need, and we will maybe have that on the next slide, we need to have another protection. And this protection could be, we will see if it works or not, European law. The European Court of Justice said in Schumacher, that's the most famous case in direct taxation from the European Court of Justice, that a community, so direct taxation does not as such fall within the purview of the community, but the powers retained by the member state must nevertheless be exercised consistently with community law. And therefore, the member states have not to discriminate. And another question, and we'll see that on the next slide, is to know if they have some other obligations. So on the next slide, please. We have first a difficulty, and we will have maybe the debate about that, which is which protection is exactly given by European law. And there are two debates, and this is the first difficulty. The first question is, do you have to apply the freedom of establishment when you have, for example, a dividend paid to a fund or an interest, or do you have to apply the free movement of capitals? And this question is an important one because freedom of establishment is working only on the territory of the member state with some extensions to some third countries, but it's limited. When you apply the free movement of capitals, it is working worldwide, and you've got a lot of cases of the European Court of Justice concerning direct taxation with states outside of the European Union or with states that do not have specific agreement with the European Union. Just know, for example, the case of emerging markets, it was a case between Poland and the US. And so the European Court explained how to choose the right fundamental freedoms with, for each freedom, some interesting points and some disadvantages. For example, it's easier for the member states to justify a restriction when you mention the free movement of capitals than when you mention the freedom of establishment. And so it's one first difficulty, which is to know what is protecting me. Then there is a second point, which is the question of the Charter on the Fundamental Rights. And it's not working a lot. I'm not sure that it can work today for the withholding taxes for one reason, which is that the Charter may be invoked only if, to be brief, the tax is harmonized at the European level. And if you are outside of the scope of tax harmonization, you are not protected by the Charter. And therefore, usually the case law that we mention is with freedom of establishment or free movement of capitals, or sometimes, because it's difficult to know which freedom has to apply, the Court of Justice applies the two freedoms together. We have some other difficulties. We go to the next slide. And the second difficulty is that under the case law of the European Court of Justice, double taxation is not prohibited. And we've got some cases. One interesting case is the OESF case, but we can mention a lot of other cases. And what we have to know is that this double taxation is considered as not prohibited by the Court of Justice. The point for the Court of Justice is that if there is a double taxation, the reason is that two member states at the same moment decided to have an exercise of the tax sovereignty. And then there is no obligation to adapt the tax system. And for example, if there was withholding tax in the state of the source, the state of residence does not have the obligation to adapt the tax system and say, okay, I give you a tax credit. And therefore, the court says, if you want to have a protection, you can use European directives. And it's clearly explained in the cases that are mentioned there. And one difficulty is that the European directives that exist, and we've got, for example, a parent subsidiary directive adopted in 1990 and modified afterwards, it does not apply to the fund. And therefore, there is no protection against double taxation. We go to another difficulty, and we go on the next slide, please. The third difficulty is the difficulty concerning the methodology. And we've got two questions, and you've got there just to show, we will not comment in detail those cases, but just to show that since Santander, and if you take only the last years, we've got numerous and difficult cases concerning the discriminations and concerning the taxation of those vehicles. And in Santander, what is interesting is that in that case, the reason why the French Conseil d'État, the French case, asked for a preliminary ruling to the Court of Justice was that two difficult questions needed to be answered. First, when you have a stakeholder, a fund, and a company is paying, for example, a dividend to the fund, and that the fund is paying something to the stakeholder, the question is, what do you have to compare? Do you say there is a withholding tax when the dividend is paid to the fund, and we compare that? Or do you say, as France, we have to take into account the stakeholder, and if he's a French one, he will be subject to income tax. And therefore, it is justifying the fact that at the origin, there is no withholding tax. When you have a company, which is, for example, Santander, the stakeholder at least is established in Spain. Therefore, it will not be taxable in France. And that's the reason why I have withholding tax. And the Court of Justice said, you have to compare everything, but you cannot say that each time you have a vehicle in Spain, you have then a stakeholder in Spain. It can be a French buying a product in Spain, investing them in France. And therefore, what you say is not always working. And so first difficulty is to know what exactly to compare, and it's always very difficult. And then the second question is, how do you compare? Because even if it's harmonized for a way, for non-tax reason, the way the vehicles are functioning in all the member states and outside of the member state are not exactly the same. And so in those cases, the European Court of Justice had to answer to difficult question, is this fund comparable to another fund in another state? Then what happened after this case law? We go to the next slide, and we will try to identify some hypocrisy. And we will see what has happened after Santander in France. We go back to our French tax code, and we see that the French law decided, therefore, that in the purely domestic situation, you will now be taxable. So how is the discrimination eliminated? Not by saying there is no withholding tax anymore on the international in the international situations, but by saying each time there was an exemption or a non-tax situation in a purely domestic situation, there will now be a new tax. So we say that the winner takes everything, and then the other taxpayers have to pay more taxes. So elimination of double taxation means you pay more taxes, everyone has to pay, and not you will be now exempt of withholding taxes. And we've got this case with a National Pension Service that has been judged 2 years ago by the French Conseil d'État. And the French Conseil d'État said, we've got not exactly a fund, it's a public establishment, which is, you mentioned it, IRCANTEX, paying them pensions, and it's now subject to tax. And therefore, the National Pension Service, it's a South Korean fund, was therefore subject to the withholding tax. And the Conseil d'État said, your situation is similar as a one of a public establishment. And that's the point in France. So in brief, each time you win at the court, then you have to pay more taxes in the national state. So take care when you go to the court. Second hypocrisy, we go to the next slide. It's at least the fact that the economical discrimination is not eliminated. And the main difficulty that needs to be resolved today is a question of the unit holders or of the retirees when you have an investment fund or a pension fund. And even if you eliminate double taxation or discrimination between the company paying a dividend, an interest, building, paying something, and a fund, then you have to take into consideration the situation of the unit holder, which at least is subject to what I call an economical discrimination. Thanks a lot.
That's it?
Yes.
Oh, yeah, that was quick. I was surprised.
So it's 10 minutes.
Yeah, that's perfect. Thank you, Monsieur Moutreau. Thank you very much for that overview. So, Ms. Wilmot, can you put some practical flesh onto this academic bone for us?
Oh, we're going to start one first. Okay.
What do you see in your practice, in your practical work, with regard to pension funds or other institutional investors?
Yeah, so I think there's a number of possibilities and considerations in that context. And generally, at any point in time, the ECJ requirements in a given market are understood, but of course they can alter. And the tax authorities, as is their prerogative, have a right at any point to change those requirements or to make additional requirements, often in the form of documentation, information, and so forth. And I think it's, you know, particularly the case now, and this has been commented on at the industry level a lot, that the uptick in scrutiny, if you will, by the tax authorities as a result of continuing to ask for additional documentation information is commensurate with the publicity and attention over recent years in terms of general tax abuse and tax avoidance activity. So to a large extent, we are reactionary, certainly as service providers, and the landscape is constantly evolving. So for that reason, from a practical and a methodology perspective, we have to keep abreast of what's going on all the time. I think there are certain themes or areas that it's perhaps worth spending a couple of minutes on that we see, certainly from our perspective as an asset servicer. The first being, interestingly, late interest payments. So some tax authorities will pay out late interest when they have agreed to honour an ECJ claim, and we see a different or disparate response to that by various different jurisdictions at the moment. For example, in Poland, they have a number of cases pending with the courts. On the face of it, the Polish tax authorities appear to be reluctant to pay late interest in that context, and there's no requirement under domestic law for them to do so. As far as we know, there's been no CJEU judgment against them, and there's nothing legal needing them to do that. Whether that will change or not remains to be seen. Conversely, in Spain, the opposite is true. Spain have paid out late interest, but they have previously been held up for using an incorrect calculation methodology in that. And so anyway, subsequent to a number of rulings being lodged in that context, positive outcomes were achieved. So we'll continue to see probably a mixed bag approach. The second theme I'll touch on, and you'll hear it a lot from me, is that of information requests. Probably, you know, the biggest area for us as a custodian and asset servicer that we see in terms of needing to respond to. By way of examples of that, and there are many, so it was trying to choose a couple of the juicier ones, I guess. You know, there were a number of cases referred in Denmark as it related to investment funds 2 or 3 years ago that were moved from the tax authorities up to the Danish National Tax Tribunal, the DNTT. And most famously in one of those cases, I think it was 2020, 2021, the DNTT, in the case of Fidelity, which had large claims pending, said, we want information, we need more press, we absolutely need to review this to the nth degree. They subsequently did that and then ruled in favour of the Danish Ministry of Finance. So after the provision of all of that additional information and documentation, they held that there was no discriminatory treatment, so there was no payout due. Conversely, in the case of France, which slightly audacious to be talking about French tax in front of you, Alessandra, but in the case of France, because we hear about this a lot when we talk about it with our clients and have done over the years, we know for non-resident pension funds there is a comparability questionnaire in this context, but we also know, or understand, correct me if I'm wrong, that around about 22, the French tax authorities, having made a number of information requests, particularly I think in the UK pension fund space, have started to receive back that information and are working through it and working through the backlog of claims as it relates to pension funds, particularly the UK pension fund sector, right back, I understand, to 2010. So again, for all different sorts of reasons, we see information requests coming down the pipes in many different forms. The other area that's worth touching on that we see thematically a lot, or discuss thematically a lot, is the movement in the third country space, which we are now on. And there's a lot of activity there. In France, again, we know that their general guidelines state that the same relief at source benefits, which may otherwise be available to EU and EEA resident investors, are not necessarily available to investors resident outside the EU and EEA, and therefore claims need to be provided. There was some discussion in the industry that that could be construed as discriminatory, but in fact, I think it was the Supreme Court held up that it wasn't an abuse of power. It was actually perfectly reasonable, given the lack of commonality in terms of regulatory framework. It was not only perfectly acceptable, but to be expected that in that situation with third countries, again, more information will be requested. So it's something that we're going to continue seeing. In terms, and that doesn't mean, by the way, there won't be success at the end of the tunnel. More recently, perhaps worth mentioning, because I know Italy is a big market, the Pescara tax courts ruled recently in April, May, on 6 individual US cases positively, and they held that the tax treatment there of outbound Italian dividends was indeed discriminatory, and as a result, there should be a repayment of taxes due. So, as a general theme, we're seeing anyway a lot of activity in the third country ruling outcome space as it relates particularly to the US and Canadian applications. And separately on this topic, I would say that there continues to be, vis-a-vis the example I gave in France, an expectation that claimants outside of the EU and the EEA will naturally be expected to provide a higher, more information than an investor resident in the EU. There is a higher burden of proof, which some may say is reasonable. And then finally, as a thematic observation, and we'll talk about this more, I'm sure, duplicate claims. So it's a big, hot area of discussion. There is a natural neurosis and concern by the tax authorities in that regard. In particular, the Norwegian tax authorities have come out and stated that in an instance where a double claiming situation may arise, that would be considered as fraud. And so as a result of that, part of the process now in Norway is that there, certainly from our experience, is that there is a need for the beneficial owner, which is interesting, nobody else in the chain, the beneficial owner to sign a per dividend event authorization that the reclaim is able to be filed. So the inference thereof is, of course, if something is later identified as being a duplicate claim or double claim, that the coupled party will be the beneficial owner. So I think we're going to continue to see that side of tax authorities wanting to ensure there are robust controls around this process continue in one way. I'll pause there.
And keeping in mind certain scandals that we've seen, it does make sense that the tax authorities are trying to avoid misuse and maybe even accidental double claiming. Mr. van der Waal, you talked about the college pension plan of British Columbia case. It's Canadian pension vehicles that suffered German withholding tax. And what is your experience with this? What was the topic? What is the problematic decision there?
Well, a lot, actually. I think it may be interesting to dig a little bit further back before we go into the college pension plan. What you see then is that when you speak to people about ECJ reclaims, it's almost like it's a relatively new development, like it's a relatively new type of reclaim, whereas it's been around for at least since 2004. A lot of people are referring to these claims as focus bank reclaims after one of the companies that filed such a reclaim, I think in 24, or at least the decision one is in 2004. And it's interesting to see that, given that it's been around for such a long time, there's still so much litigation around ECJ reclaims. And you would think that, almost 20 years after some of the first cases, a lot of this would have been clarified by now, the application of the free movement of capital. And yet it has gone through so many phases. There's been sort of waves of litigation for ECJ reclaims. And we saw that reflected in the college pension plan case. Because when the college pension plan case was filed, some of those waves of litigation had already been passed through. I remember way before the college pension plan case, there was litigation about whether the free movement of capital should actually, or has actually the same extent or the same reach between a member state and a non-member state, such as Canada, as it has between two EU member states. And the position there of many tax authorities was that because the legal framework between member states is quite different from the legal framework between a member state and a third state, looking at the EU directives on administrative cooperation and transparency, that the free movement of capital should be applied more restrictively towards third country claimants. And that was categorically dismissed by the ECJ in at least one case, which is called the Haribo case. It dates back to 2011, where basically the ECJ said, well, if we look at the clear language of Article 63, which is where the free movement of capital is laid down, it clearly states that it is applicable to not only between member states, but also between a member state and a third state. So if you, as an EU, had meant to apply the free movement of capital more restrictively to third country claimants, then you should have written that down in the treaty, and you didn't. So that was clearly off the table. Free movement of capital had equal strength, if you will, between a member state and a non-member state from the Haribo case onwards. Then we had other litigation about, if there is a restriction on the free movement of capital, which is often the case, it might be justified by what they call overriding reasons in the public interest. There's been litigation about that as well. What are overriding reasons in the public interest? And can they sort of justify a restriction on the free movement of capital? And there again, the general outcome of litigation was that there were hardly ever overriding reasons in the public interest that could justify an infringement of the free movement of capital. So that was pretty much off the table as well. Then in 2015, there was a case called Wagner, where the tax authorities tried to say that the free movement of capital could actually be restricted under the so-called standstill provision. The standstill provision is Article 64 of the EU Treaty, and it basically says that if you had restrictions present in your domestic tax laws that already existed on the 31st of December 1993, then those restrictions of the free movement of capital could be grandfathered, because 1994 was the first year in which the free movement of capital was actually extended towards third countries. And the basic premise there was that, member states were unable to anticipate that. So to the extent that they had existing restrictions of the free movement of capital in their domestic tax laws, they were able to continue to apply those. Obviously, they were not allowed to impose new restrictions after 1994, but the existing restrictions would be justified. So they tried that as well. The difficulty is that the free movement of capital, by its wording, only applies to direct investment, which means investments of 10% or more in the share capital of a company, which by definition means that it doesn't apply to portfolio investment, which generally are, small pieces of ownership in securities or bonds or shares or whatever. So as a general rule, the standstill provision could not apply to portfolio investment, which is good news to pension plans like college pension plan, but also most investment funds, which tend to have portfolio investments rather than direct investments. Then they saw that the standstill provision also referred to providing financial services. So they said, well, maybe we can say that what pension funds are doing, the investments that they're making in portfolio investments actually are financial services that they're providing to their pensioners. So then we can say that the standstill provision actually does apply to the free movement of capital, and it can grandfather the restrictions that we have in our domestic tax laws. That was dismissed in the college pension plan case, which I think still is a very important part. It's not maybe not perceived as the highlight of the college pension plan case, but it's definitely a very important part, because from that point onwards, I think that trying to salvage restrictions on the free movement of capital under the standstill provision, at least for portfolio investment, had come to a definite stop. And then finally, I think maybe the highlight of the college pension plan case is what ECJ litigation on the free movement of capital in relation to portfolio management has focused on since then, after all of these sort of exits have been cut off by the ECJ, is the matter of objective comparability, which comes down to the heart of the question: is there a tax discrimination? Are you treating foreign claimants worse, or are you subjecting them to a harder or a heavier tax burden than your domestic counterparts? And of course, you always have to compare apples with apples. So you can't compare an investment fund with a pension fund and vice versa. In that particular case, the ECJ has repeated what it has said in so many cases, which is that when a member state decides to subject foreign investors to a withholding tax, and not only its domestic investors, then by definition, they are, from a tax perspective, in an objectively comparable situation. So I think actually, and that's also what the ECJ said, the sort of the exception of objective uncomparability is a very stringent test, which is a derogation of the much more fundamental principle of the free movement of capital, and therefore the exception of objective uncomparability has to be applied very restrictively, which is exactly what the German court has not done. So getting to the punchline, the ECJ said in the college pension plan case that if college pension plan allocates its dividend income for its pension provisions to pay future liabilities like German pension funds do, then it is in a objectively comparable situation with German pension funds, and it is entitled to a refund of withholding taxes. This case was then referred back to the German court, who has the final say, taking into account the ruling from the ECJ. And the German tax court actually did quite the opposite. They did not apply the objective comparability test very stringently, but they actually took a magnifying glass and looked at the way in which German pension funds create liabilities for future pension payments, and compared the mechanics of how that works in Germany to how that is being applied in Canada. And obviously, when you do that, when you deep dive into details such as those, you are bound to find differences between domestic and foreign pension funds, which of course they did. So the end result, paradoxically, in college pension plan is that the German referring court said, well, we actually don't think that college pension plan is objectively comparable to German pension funds. So we're back at square one.
And they denied this because of the technicalities of the reserve building.
Exactly.
What's that? Dear panelists, our 50 minutes are not enough for our topic, and I see that all of you are very interested in this. Professor Métaux de la Motte, in 3, 4, 5 years, where could we possibly, or ideally, where could this topic be? You showed us a slide with, I think they were 15 different cases, all of them based on national tax law, but we are in an EU environment here. Do you have a thought? Where could we be in 3, 4, 5 years? So we have only a few more minutes left, sorry.
Okay. Today, the situation is not a very good situation, whatever the efforts made by everyone, because all the cases that we have mentioned, they are really not predictable. And you do not know what will be the result of a comparison. And the reason you have just mentioned that is that we need to have an objective comparable test. And what is the goal of the rule? We are talking about taxation. So the goal of the rule is to tax. And so it's very difficult, therefore, to have a comparison. It could be working well, and so we do not have to wait too much from the European Court of Justice. The main difficulty, at least, is the fact that we have an economical discrimination in the international situations. And until the European Court of Justice considers that we do not have, that a member state doesn't have the obligation to adapt its own tax system to the other systems, and that double taxation, it seems strange on an economical point of view, double taxation is not an obstacle to the fundamental freedoms. On an economical point of view, it's wrong, but in law, it is true. And therefore, we cannot ask too much to the European Court of Justice. And what must then be done? Harmonization is not prior. There are a lot of other projects. We talk about Parallel 2, for example, today. So harmonization of this question is not prior for the European Commission and for the member state. And therefore, one solution could be between nothing and harmonization, mutual recognition by the member states. And if you have this mutual recognition, you say, for example, you have a fund in Germany is exempted of tax. It has, therefore, to have consequences, and if it is exempted in Germany, no tax must be levied in France. And then at least you have only one tax, which is the tax paid by the stakeholder in the state where he is a resident. So it could be a solution. Now, it's more a political solution, but if harmonization may not happen, if the European Court of Justice may not decide that double taxation is contrary to the treaty, mutual recognition could be the best way to have a common action.
Ms. Wilmot, your last word.
Okay, I'll be very quick. 2 points. Firstly, like you, we all expected in the asset servicing community, the volume of reclaims in this context to come down. They haven't. There's lots of reasons why that might be the case. We haven't got time to go into. But I do think there's an interesting point here as it connects to faster, which everybody will be talking about ad nauseum today, I'm sure, in different contexts, which is although let's assume it does continue to go on the path it's set and the post-27 implementation world is, you know, a place of perfection. We're all either relief at source or quick refund, but we will still be living with a long tail end, I think, lag of ECJ claims to clear for a while yet. The second thing, and this really came to mind when Ali was speaking, where's Ali? In that lovely opening speech, which was very touching. There is method in my madness, bear with me. And that is in the context of ESG. And I know this isn't a panel on the ESG, but we all know that tax is rising rapidly up the ESG agenda. It hits all the E, the S, and the G. The S is all about public contribution, anti-abuse activity, a real willingness to offer readily information. The G is about transparency, controls, all underpinned by clear tax strategy. There is an argument that one could say to the fiscal authorities in the EU, is it in the spirit of the S, the social, that you are forcing, arguably, pension funds to undergo litigation to claw back that which is arguably legitimately theirs? I would also add that the fragmented, burdensome process around ECJ that we all live with all of the time is equally against the spirit of the G. And I'll stop there.
Thank you very much, ladies and gentlemen. Thank you very much, dear panelists. And that's it.
Thank you very much.